The Supreme Court denied the bail to student activists Sharjeel Imam and Umar Khalid, who had challenged the Delhi High Court order denying them the bail in the case filed under the Stringent Unlawful Activities Prevention Act, or the UAPA, linked to the alleged larger conspiracy of the 2020 Delhi riots. The Supreme Court, however, granted bail to 5 others in the case, all of them Gulfisha Fatima, Miran Haider, Shifa ur Rahman, Mohammad Salim Khan and Shadab Ahmed were granted bail. The court said that they cannot, in fact, treat all individuals equally for bail. The Supreme Court had also said the record discloses that all appellants do not stand an equal footing in that regard. The Supreme Court, remember, went on to, in fact, give details about Article 21, and it raises a very, very important question about how, when it comes to Article 21 and how pre-trial detention is concerned. 5 years, both of them have been behind prison, behind bars, and even the court now says that they can only apply for bail after 1 year, or if the deposition of all the key witnesses is done. That's a very, very important, in fact, judgment that the court has given. But let me very quickly tell you, in fact, little details about the affidavit which was filed, the cases which were filed, the charges which were again brought against Umar Khalid. What the Delhi police affidavit said: chief conspirator of the Delhi riots in 2020 is the allegation of the Delhi police, mentored Sharjeel Imam in 2019. They also said that WhatsApp chats in December 2019 show that he played an active role in what happened later in 2020. And he also formed a WhatsApp group, Muslim students of JNU and students of Jamia. Sharjeel Imam has also been, remember, denied bail. I'll get you the details on what the police said about him as well. Conceptualized Shaheen Bagh and Jamia Chakka Jam as well. And they also said instructed Selampur women to stockpile weapons. This is a serious charge that they have made. All these charges will have to stand the scrutiny of the law. Let's move on and bring you what Sharjeel Imam, the affidavit for police has in fact put for Sharjeel Imam, conspired and executed the first phase of the Delhi riots. That's what the accusation is. Engineered Chakka Jam in Shaheen Bagh, akin to what in fact they said in both these cases, induced imams of masjids to incite the mobs. These are, ladies and gentlemen, remember, these are allegations which have been made by the Delhi police. They have to, in fact, whenever the trial starts, because it's been 5 years, the trial hasn't started, they will have to justify all these charges under UAPA, gave insightful speeches at Jamia Millia Islamia, and also formed protest plans on WhatsApp group. The question is it all? Can, protesting against the government, can that be taken as an instrument to throw the government out? Let me very quickly at this moment go across to Mr. SV Raju, Additional Solicitor General, Supreme Court. He is the key, in fact, lawyer key legal luminary who, in fact, argued for the Delhi police, both in the High Court of Delhi and in the Supreme Court. Thank you so much, Mr. Raju, for joining me at this moment. Let me begin by asking you, sir, first of all, your reaction to the judgment of the Supreme Court denying bail to Umar Khalid and Sharjeel Imam while giving bail to 5 others.
See, I have not seen the judgment because I'm traveling, but I was present during the pronouncement, and from the pronouncement I've seen that it's a lengthy judgment. It's very well written. They've considered almost all the aspects that has been argued, and it's a beautiful judgment. And I think the judgment is correct when it refuses bail to Umar Khalid and this guy, Sharjeel Imam. So, and they've considered the evidence that we have produced. They've considered the law, and they've considered the fact that delay is attributable to them.
But what is the distinction that has been made between them and the others in this case? They are also facing more or less similar charges. The court said that they are standing on a different footing. What do you make of that, sir?
See, as I told you, I have not read the judgment. It's my guess, which I will be able to only justify after I read the judgment. The court must have probably seen the facts and distinguished the role as far as the other five are concerned. These two people, Sharjeel Imam and Umar Khalid, are the masterminds. Therefore, their role is definitely different from the role of the other five. That probably must have weighed in with the courts. But this is only guesswork since I have not read the judgment.
No, why I'm asking you this question, sir, because it has been pointed out that Sharjeel Imam, while the 2020 riots were on, before that he was already in prison. Umar Khalid, out of the 75 cases of Delhi riots 2020, he's accused in just one. So how does this make them the mastermind of the larger conspiracy?
See, whether you're in jail in an earlier period of time hardly makes any difference. What is your role? And the role has been demonstrated not only by videos, by WhatsApp chats, by statements of witnesses, other documents, etc. We have played a video where he says that Assam should be separated from India, chicken neck should be cut off. Now, these type of statements are totally anti-national, and such types of things should not be tolerated as far as India is concerned. And the fact that you're in jail in other matter or supports our case that he is involved in other matters also.
Okay, but how does that make him the conspirator of this one? That is a question. But I also want to understand from you, the court has barred them from applying for bail for 1 year or before the key witnesses have been deposed of. I just want to understand from you, does that legally mean that they have no option now left for at least a year? They have already been in the jail for last 5 years, and now for another year, there is no option for them to apply for bail.
See, the law as far as bail is concerned, you can always make a fresh bail application if there are change in circumstances. Okay. If there is no material change in circumstances, you can't make a fresh bail application after your earlier is rejected. Okay. Ordinarily, if the Supreme Court has rejected a bail on merits, no trial court would grant you bail because there is a Supreme Court judgment which is staring at you. Correct? So, even if they had moved after 1 year, they would not be entitled. The court would say, "Oh, you lost till the Supreme Court. There's a prima facie case against you. You argued most of the points. You will not get bail." But it's actually in favor of the accused. The Supreme Court said, "Despite our judgment, you can move the court after 1 year. We give you that liberty. You can almost re-argue your case." So it doesn't bar them. You can always make an application. But no, the issue is making of an application and decision in your favor are two different issues. So if the Supreme Court has decided there's a case against you, which court is going to say the Supreme Court is wrong and I'm giving you bail unless there's a change in circumstances which warrants such a change?
But let me ask you this in conclusion, Mr. Raju. If the Supreme Court speaks about the continued incarceration, as far as these accused are concerned, and says not yet cross the threshold of constitutional impermissibility, is it effectively saying that nearly 5 years of imprisonment without trial does not amount to violation of Article 21?
There is no standard fixed. That 5 years, it's not a mathematical or arithmetic solution that 5 years grant bail. That's not the law. You'll have to look at the facts of the case, the nature of the offense, the role of the accused, and whether the delay is caused by them. There are several factors which are required to be considered. Take a case of a serial killer. You say 7 years in jail, trial is not proceeded with. Then you say release him on bail so that he can kill a few more people. That can't be the law. So there is no straitjacket formula that number of years in jail you have to be bailed out. That's not the law. You have to look at the facts of each case. Each case has to be tested on its own facts and evidence and the law.
Mr. Raju, thank you so much for speaking to me at this moment on this very important issue. Let me also go across to Mr. Colin Gonsalves, Supreme Court senior lawyer who's joining me at this moment. Mr. Gonsalves, thank you so much for speaking to us. You heard Mr. Raju speaking just before you, sir. Let me ask you this question as well. The court, by saying that it has not, impinged the 5-year incarceration, is still not crossed that threshold. What does that mean? Does it mean that people can be incarcerated for as long as the prosecution wants them, even before the trial starts? Isn't this the violation of Article 21?
Of course it is. It's a shockingly wrong judgment. It's contrary to a 3-judge bench decision of our Chief Justice of India in a 4-year case where the trial had not proceeded. And the Najib judgment clearly says that is a violation of your right to life under Article 21. You want to do a trial, do it quickly. But if you don't do it for 4 years, then here it's 5 years, then you must release him on bail. I don't know how a bench of the Supreme Court of a lesser strength, 2-judge bench, the present one, how they could be so categoric in saying, for lack of a better word, so categoric in saying that you will stay in jail notwithstanding the 5 years delay. It's shocking. It's like the emergency judgment of the Supreme Court. It's as bad as that.
Can I understand?
I tell you one thing as well.
Yes.
Just like the emergency judgment, years down the line, when the things are sorted out in the Supreme Court, these persons who are in jail for no violence at all, not a single act of violence, no gun, no knife, no bomb, no drone, these persons will be recognized as India's foremost freedom fighters. And the judiciary will have to reconcile with putting India's freedom fighters who fight for justice.
But what would you say? What would you, Mr. Raju also said that this whole delay is on the account of the accused as only. It's not, the court has also accepted the fact that the delay in starting of the trial is on the account of the accused, not on the account of prosecution.
That's not a factually correct statement. I heard the arguments from beginning to end. Look, the conduct of the court trial is entirely in hand of the prosecution. Prosecution wants to proceed fast. No power on earth can make them slow down. No strategy by the accused to avoid can make them slow down. This was the case where the prosecution wanted to delay because they knew that when the trial starts and when the matter comes on evidence, these persons will be acquitted. In many UAPA cases, they know it's storytelling. Prosecution gives you a story about how terrible they are. And they know that if they come to court, that story will be destroyed in a minute. So the prosecution in all UAPA cases wants to drag on the case so that people suffer incarceration without a conviction. That's the strategy. Put them in jail, no conviction, keep them in jail. So even if they are acquitted after 7, 8, 9 years, they've served their sentence. That's the strategy. It's shocking, really. It's unbelievable.
And very quickly, in conclusion, because I'm completely out of time, the court has also put in some restrictions as far as them applying for bail is concerned. They have now said that you can't apply for bail for at least 1 year, and you can only apply for bail if the key witnesses have been deposed of. How does that, how is it justified? Can this be justified legally, taking the right away for even
I tell you, all your questions answer themselves, really. Yeah, all your questions are absolutely pertinent. There's no justification for this. It's total lawlessness, if you ask me. This judgment is total lawlessness. This is, to me, after 35 years of practice, the signal of the death of the judiciary as far as human rights is concerned. It's the end of the Supreme Court. And respect and love for the Supreme Court that I had when I joined is destroyed today.
Mr. Gonsalves, thank you so much for taking the time out and speaking to us here on NDTV.